everyone, welcome back to RR Corporates. Today we are discussing an extremely important ruling by the Punjab and Haryana High Court regarding the power of RERA authorities. RERA cannot order for demolition. Key judgment explained in the matter of Parveen Gambhir versus Union of India. In case of Parveen Gambhir versus Union of India and others, the court clarified that RERA authorities have no power to order demolition for deviation from sanctioned building plans. Let's dive into the case, the law, and what it means for developers, buyers, and real estate industry. Now I will explain background of the case. A group of home buyers file a case before RERA authority alleging that the developer had made unauthorized constructions and deviations from approved building plan. The buyers sought not just penalties but also demolition of the unauthorized structure through intervention. So the matter escalated, leading to writ petition before Honorable Punjab and Haryana High Courts. Then the court issued before the Honorable Court whether RERA authorities have the power to order demolition of unauthorized constructions that deviate from sanctioned building plans. This is the core issue. So that we will go to the relevant provisions under the RERA Act. So let's understand the scope of powers under RERA. Section 31 allows any aggrieved person to file a complaint with the authority regarding violation of the Act or rules. Further, Section 34 says the list of functions of RERA authority. Regulation and promotion of real estate sector. Ensuring compliance with obligations. Safeguarding consumer interest. And Section 35 and 36 says powers to issue direction to promoters, agents, allottees to comply with obligations. Come to Section 38, powers to impose penalties and interests. Orders for compensation. So there is no express power to demolish buildings. Section 38 says powers to impose penalties and no interest. Pass orders for compensation. Section 38 says power to impose penalties and interest. Pass orders for compensation, but no express power to demolish buildings. Section 11, duties of promoters. So they must adhere to sanctioned plans and project specifications. So that is the duty of the promoters. So here nowhere does RERA Act empower the authority to pass orders for demolition of construction. So here the important demolition powers are typically conferred under municipal laws, like the Punjab Municipal Corporation Act, because the case is under this jurisdiction, or local buildings bylaws. So there is no, these powers are not with RERA authority. So what the court held, so the division bench comprising Justice Sureshwar Thakur and Justice Vikas Suri held, RERA's jurisdiction is regulatory and adjudicatory. So it means to protect the interest of home buyers, ensure fair practices, and penalize errant promoter. So demolition involves administrative action based on violation of building laws, not just a private contractual grievance. Therefore, only municipal authorities or urban development authorities under relevant laws have the power to pass orders for demolition. So the RERA cannot assume powers not conferred upon it by the statute. Here, the principle of limited jurisdiction comes into the picture. So, RERA cannot assume the powers not conferred upon it by the statute. So, the quote from the judgment is the RERA authorities have no jurisdiction to order demolition for deviation from sanctioned building plans. Such powers are within the domain of municipal authorities as per the applicable local laws. So, what would be the impact of the judgment? We will see for home buyers. So, home buyers can still approach RERA for compensation, a refund, penalty for deviations. But for demolition, the home buyers must approach municipal authorities or file a separate suit. Impact on the developers. Deviations may lead to penalty under RERA. Unauthorized construction may also attract action from all authorities. So the impact for RERA authorities must confine their actions strictly within the Act, cannot overstep into areas governed by local municipal laws. So now the conclusion is this landmark ruling by Honorable Punjab and Haryana High Court reaffirms the principle that regulatory authorities must act strictly within the powers given by their enabling statutes. For deviations in construction, buyers must seek remedies under municipal laws, not before RERA. So for more such important updates on RERA, real estate laws, and landmark judgments, subscribe to our channel, RR Corporates, and other channel, RR Legal Talks, for legal updates, and hit the bell icon. Thank you for watching and stay informed. So I will show you the full judgment. I'll stop here. Go to Google, and if you see, type Indian Kanun.org. There we can see the full order. Punjab, Haryana High Court, Parveen Gambhir and Others versus Union of India and Others on 1st April 2025. You can find full details. If you want to go to full judgment, you can go through. The bench consists of Justice, it is given, Vikas Suri, Thakur, Sureshwar Thakur, CWB number 23526 of 2021. In the High Court of Punjab and Haryana at Chandigarh. This is reserved on 18th February 2025. Date of decision 1st April 2025. Petitioners Parveen Gambhir and Others versus Union of India and Others respondents. The quorum, Honorable Mr. Justice Sureshwar Thakur, Honorable Mr. Justice Vikas Suri, and argued by advocates for petitioner side and respondent sides. You can go through. Thank you.